Question 1. Trust administration during a comprehensive review of a process that needs improvement. A trustee of a large irrevocable trust overseeing substantial real estate assets discovers that a high-value commercial property within the trust is underperforming due to poor management. The trustee considers selling the property and reinvesting in a diversified portfolio to maximize returns for the beneficiaries. However, a contingent benefit challenges the decision, arguing that the trustee has a duty to maintain the trust assets as originally intended. What is the trustee's best course of action under fiduciary law? A. Sell the property immediately, as the trustee has absolute discretion over trust assets. B. Petition the court for approval to sell, demonstrating that it is in the best interests of the beneficiaries. C. Do nothing, as any alteration of trust assets without beneficiary consent constitutes breach of fiduciary duty. D. Seek unanimous approval from all beneficiaries before making any changes to trust assets. Answer. B. Petition the court for approval to sell, demonstrating that it is in the best interests of the beneficiaries. Explanation. A trustee has a fiduciary duty to act prudently and in the best interest of the beneficiaries under the Uniform Trust Code (RSS), which requires trustees to administer the trust as prudent person would. This includes the duty to diversify investments and act in a way that preserves and enhances the value of the trust. A. Incorrect. While trustees have discretion, they are still bound by fiduciary duties such as prudence and loyalty. Absolute discretion does not mean unlimited power to act without oversight. C. Incorrect. Doing nothing could be considered breach of duty under Restatement III of Trusts, which encourages trustees to take proactive steps in asset management. D. Incorrect. While beneficiary consent is valuable, trustee is not legally required to obtain unanimous approval from all beneficiaries before taking actions within the trust's best interests. Instead, approval ensures legal compliance. Thus, the trustee should petition the court to demonstrate due diligence and ensure that the decision aligns with fiduciary obligations. Question 2. Will contests undue influence? While examining inconsistencies across various units, an elderly testator executes a will leaving her entire estate to a living caregiver who had recently become the testator's power of attorney. The testator's children, who were previously named as beneficiaries in an earlier will, challenged the new will, alleging undue influence. Under what circumstances would the court most likely find undue influence and invalidate the will? A. The caregiver was present at the will signing but did not actively influence the testator's decisions. B. The testator's mental capacity was questionable and the caregiver was actively involved in drafting the will. C. The caregiver received large bequests, but the testator had always intended to leave her estate to close friend or caregiver. D. The testator independently consulted with an attorney and executed the will in formal setting. Answer. B. The testator's mental capacity was questionable and the caregiver was actively involved in drafting the will. Explanation. Will can be contested for undue influence if it can be shown that the testator was coerced or manipulated into making decisions they otherwise would not have made. Courts typically assess 4 key elements of undue influence under the Restatement III of Property, wills and other donative transfers. Susceptibility. The testator, vulnerable due to age, illness, or mental incapacity. Opportunity. The influencer had access and control over the testator. Motive. The influencer stood to benefit significantly from the will. Active participation. The influencer was involved in the will's preparation. A. Incorrect. Mere presence at the will signing does not necessarily amount to undue influence unless active pressure was exerted. C. Incorrect. Even if large bequest is suspicious, the testator's intent matters. If the will reflects long-standing wishes, undue influence is harder to prove. D. Incorrect. Independent legal counsel strengthens the presumption of voluntary intent, reducing the likelihood of successful undue influence claim. Because the caregiver controlled drafting process and the testator's mental capacity was in question, court would likely find undue influence and invalidate the will. Question 3. Generation skipping transfer to Gieti. In a case where multiple parties have different objectives, a wealthy individual establishes a trust for their grandchildren intending to pass assets directly to them while avoiding estate tax upon the death of their children. The trust holds $5 million in assets. However, the IRS audits the estate, asserting that the transfer is subject to the generation skipping transfer to Gieti. Under what condition would Gieti apply? A. The trust was properly structured as a dynasty trust. Gieti does not apply. B. The assets were transferred directly to the grandchildren. and the transfer exceeded GST exemption. C. The transfer qualifies for the annual exclusion, so the IRS cannot amend GTT. D. The children were granted life estates in the trust which prevent GTT from applying. Answer B. The assets were transferred directly to the grandchildren and the transfer exceeded GRT exemption. Explanation. The generation skipping transfer to GT is imposed under RIAS 601-2664 to prevent wealthy individuals from avoiding estate taxes by skipping generation when transferring assets. A. Incorrect. While dynasty trusts can be structured to reduce tax liability, they do not inherently avoid DST unless properly planned with exemptions and allocations. C. Incorrect. The annual exclusion under RIAS SSB applies only to outright gifts and does not shield large transfers for a GT. D. Incorrect. Life estate given to the children may DGET but does not eliminate it, as the trust still eventually transfers asset. The grandchildren GFTT applies when assets are transferred to skip the person's e.g. grandchildren in amounts exceeding the lifetime GST exemption $12.92 million in 2023. Since the trust holds $5 million, it may or may not be taxable depending on the grantor's remaining exemption. However, absent proper exemption allocation, GFTT applies at 40% tax rate on the excess amount. Question 4. During a comprehensive review of a process that needs improvement, an estate planning attorney discovers that a client's revocable trust was never properly funded. The client, who created the trust 10 years ago, has since acquired several valuable assets, including real estate and investment accounts, but failed to transfer them into the trust's ownership. The client will contains pour-over provision directing remaining assets to the trust. Death, but there are concerns about probate delays and potential creditor claims. Which of the following options would best address the client's situation to ensure efficient asset transfer and minimal legal complications? A. Amend the revocable trust to clarify its intent and avoid probate. B. Execute and record new deeds, update financial accounts, and properly retitle assets into the trust's name. C. File petition with the probate court to retroactively fund the trust, ensuring the assets are covered under its terms. D. Rely on the pour-over will to transfer assets at death, as probate is inevitable regardless of funding. Answer B. Execute and record new deeds, update financial accounts, and properly retitle assets into the trust's name. Explanation. Revocable trust is only effective in avoiding probate if it is properly funded during the grantor's lifetime. Transferring assets into the trust ensures that they are governed by its terms and avoid the probate process. A. Incorrect. Amending the trust does not resolve the issue if assets remain outside of it. The trust's terms apply only to assets legally transferred to it. B. Correct. The best approach is to retitle real estate, reassign financial accounts, and execute transfers to ensure the trust governs these assets. This proactive step avoids probate and ensures proper distribution per the trust's terms. C. Incorrect. Courts generally do not retroactively trusts unless there is clear and convincing evidence of intent. Some jurisdictions recognize equitable reformation, but this is not guaranteed remedy. D. Incorrect. While pour-over wills do work, they still require probate administration, potentially leading to delays and increased costs. Book relevant law and guidance. The Uniform Trust Code SS 401 requires that trusts be funded to be effective, and courts have upheld the necessity of proper asset titling in cases like Estate of Hegstead, 1993, 6. Cal. App. 4th 943, where California courts recognized written declaration of trust ownership even without formal transfers. Question 5. While analyzing the root causes of sequential problems in estate administration, an executor encounters a dispute over elective share rights. A surviving spouse has filed for an elective share under state law, but the deceased had used irrevocable trusts to transfer most assets out of the probate estate before death. The state's elective share statute allows spouse to claim percentage of the deceased's estate, but there is ambiguity about non-probate assets count toward this calculation. How should the executor respond to the surviving spouse's claim? A. Deny the claim, as irrevocable trusts remove assets from the probate estate and thus from elective share calculations. B. Approve the claim for the statutory share, including assets in revocable trusts but excluding irrevocable transfers. C. Assess whether the state follows an augmented estate approach, which may include certain non-probate transfers in the elective share calculation. D. Argue that elective share rights only apply when will is and dismiss the claim based on the decedent's use of trusts. Answer C. Assess whether the state follows an augmented estate to approach, which may include certain non-probate transfers in the elective share calculation. Explanation: elective share laws protect surviving spouses from disinheritance by allowing them to claim percentage of the deceased spouse's estate. Some states calculate this share based only on probate assets, while others use an augmented estate approach that includes certain non-probate transfers. A. Incorrect. Many jurisdictions include some irrevocable trust assets in elective share calculations, especially if the deceased retained control or benefits from them. B. Incorrect. While revocable trusts are often included, excluding irrevocable transfers outright may not be valid in states with augmented estate rules. C. Correct. The executor should analyze the state-specific laws regarding elective shares and non-probate transfers. Following the Uniform Probate Code, SS 202 include non-probate assets in the elective share calculation. D. Incorrect. Elective share rights exist regardless of whether the deceased left will, so dismissing the claim on that basis is invalid. Book Relevant Law and Guidance. The UX augmented estate model includes life insurance, joint accounts, and certain trust assets in the elective share calculation in Re-Estate of 99A.3-1145 par. 2014 affirmed that spouses' elective share may extend to trust assets depending on state law. Question 6. In a case where multiple parties have different objectives, a trustee of a discretionary trust must decide whether to approve a large distribution request. The primary beneficiary, who has a history of reckless spending, is requesting a significant sum for a speculative business venture. The trust instrument grants the trustee full discretion but also contains a spendthrift clause designed to protect assets from waste. Secondary beneficiaries have concern about depleting the trust's principal. How should the trustee proceed? A. Approve the request since the trust allows discretionary distributions and does not explicitly prohibit business investments. B. Deny the request, citing the spendthrift clause and the trustee's fiduciary duty to preserve trust assets. C. Seek court guidance to determine whether the distribution aligns with the trust's overall purpose and beneficiary interests. D. Offer partial distribution with conditions on how funds may be used to mitigate risk while still benefiting the primary beneficiary. Answer: B. Deny the request, citing the spendthrift clause and the trustee's fiduciary duty to preserve trust assets. Explanation: Trustee has fiduciary duty to act in the best interests of the trust and its beneficiaries. When trust contains spendthrift clause, it is designed to protect against reckless spending and prevent creditors from accessing trust funds. A. Incorrect. Even though discretionary distributions are allowed, the trustee must act prudently and in accordance with the trust's purpose. Reckless investment could be breach of fiduciary duty. B. Correct. The trustee should prioritize asset preservation and uphold the spendthrift provision. Courts have repeatedly upheld the validity of spendthrift clauses in limiting beneficiary control over trust assets. C. Incorrect. While court guidance is an option, unnecessary when the trust terms are clear and the trustee has discretionary authority, seeking court approval may also lead to unnecessary legal costs. D. Incorrect. Conditional distribution might still contradict the trust's intent to protect assets, particularly if the business venture is high risk. Book Relevant Law and Guidance. The Restatement Third of Trusts SS 50 and Uniform Trust Code SS 504 confirm that spendthrift provisions limit beneficiaries' ability to demand distributions. Courts have upheld trustee discretion in cases like in Re Trust of Lane 660N, W. Toward 421 Min. CT. App. 2003. Question 7. In a high-stakes environment where multiple challenges arise in estate administration, a personal representative is faced with distributing assets from a decedent's estate. Contains residuary clause, but does not specifically mention certain high-value assets that were acquired after the will was executed. Dispute has arisen among the beneficiaries regarding how these assets should be distributed. Which legal principle would most likely govern distribution of these omitted assets? A. Redemption by extinction. B. Lapse and anti-lapse statutes. C. Doctrine of incorporation by reference. D. Doctrine of partial intestacy. Answer: D. Doctrine of partial intestacy. Explanation: under the doctrine of partial intestacy, if a will does not explicitly dispose of certain assets, those assets pass under the rules of intestate succession. This often happens when a testator acquires property after executing a will but does not update it with a codicil or a new will. Ademption by extinction applies when a specifically devised asset is no longer in the estate at the testator's death, make bequest fail. This is not applicable here, as the assets in question were never addressed in the will. Lapse and anti-lapse statutes deal with what happens when a named beneficiary in a will predeceases the testator. This does not relate to omitted assets. Doctrine of incorporation by reference allows external documents to be treated as part of the will if certain conditions are met, but it does not apply when a will entirely omits assets. Since the testator provide for these assets in the will, they pass as if no will existed regarding them, falling into intestate succession. Question 8. When implementing backup procedures across various estate planning documents and attorney drafts, a revocable trust for a client, the client also executes a pour-over will intending to transfer any remaining probate assets into the trust upon death. However, if the client unexpectedly passes away before formally funding the trust, how will the assets be handled? A. The assets will pass under intestate succession laws because the trust was unfunded. B. The assets will pour over into the trust only if the jurisdiction follows the doctrine of independent legal significance. C. The assets will automatically become part of the trust as intended by the pour-over will. D. The assets will be distributed according to the residuary clause of the will if any exists. Answer. C. The assets will automatically become part of the trust as intended by the pour-over will. Explanation. A pour-over will is designed to transfer probate assets into a trust upon the testator's death. The key issue is whether the trust was funded during the testator's lifetime. In many jurisdictions, pour-over will is enforceable even if the trust was unfunded at the time of death, so long as the trust is identified in the will and is a valid legal instrument. Some states require the trust to have independent legal significance at the time of the testator's death, meaning it must have been properly created even if unfunded. The assets do not pass through intestate succession unless the pour-over mechanism is legally invalid. Thus, the correct answer is C. The assets will pour over into the trust per the terms of the will. Question 9. While analyzing the root causes of sequential problems in estate tax liability, an estate planning attorney must determine whether a taxable gift made during the decedent's lifetime should be included in the gross estate for federal estate tax purposes. Under what circumstances would the IRA include the gifted asset back into the estate? A. If the gift was made within 3 years of death, unless it was given to spouse or qualified charity. B. If the decedent retained life interest in the gifted property, but only if the interest was explicitly documented in trust. C. If the gift was below the annual exclusion amount but was made to non-U.S. citizen. D. If the gift was made through revocable trust, regardless of whether the decedent retained control. Answer A. If the gift was made within 3 years of death, unless it was given to a spouse or qualified charity. Explanation. Under Section 2035 of the Internal Revenue Code, gifts made within 3 years of the decedent's death are generally included in the taxable estate if they involve relinquishment of certain retained powers or interests, such as life income rights or reversionary interests. Answer is correct because gifts made within 3 years of death, particularly those that include transferred life insurance policies or property with retained rights, are pulled back into the estate for tax purposes. Answer B is incorrect because retained life interests cause inclusion under RSSS even beyond 3 years. Answer C is incorrect because the annual exclusion applies regardless of the recipient's citizenship. Answer D is incorrect because revocable trust does not constitute completed gift until it becomes irrevocable. Thus, gifts made within 3 years of death are included in the gross estate unless given to spouse or charity, making the correct answer. Question 10. In a scenario where efficiency decreases across multiple estate settlements due to probate delays, an estate planning attorney advises a client to use a transfer on death TOD deed for real property. What is the primary advantage of using a TOD deed in estate planning? A. It allows real estate to be transferred outside of probate while retaining full control during the owner's lifetime. B. It immediately transfers ownership to the beneficiary upon execution, avoiding any future disputes. C. It eliminates estate tax liability on the property by excluding it from the taxable estate. D. It requires the property to be placed in an irrevocable trust to ensure seamless transfer. Answer A. Allows real estate to be transferred outside of probate while retaining full control during the owner's lifetime. Explanation. A transfer on death TOD deed allows an owner to name a beneficiary who will receive the property upon the owner's death bypassing probate. Answer is correct because the owner retains full control over the property during their lifetime, including the ability to revoke the TOD designation. Answer B is incorrect because the property does not transfer immediately upon execution. It only transfers upon the owner's death. Answer C is incorrect because TOD property is still included in the taxable estate for estate tax purposes. Answer D is incorrect because TOD D does not require the use of trust. The correct answer is it allows probate avoidance while keeping control in the owner's hands. Question 11. While investigating a complicated issue between different beneficiaries, an executor encounters a situation where a will's language is ambiguous regarding specific bequests. What legal principle is most commonly used by courts to resolve such ambiguities? A. The doctrine of cypres. B. The doctrine of dependent relative revocation. C. The rule of perpetuities. D. The doctrine of construing ambiguities against the drafter. Answer D. The doctrine of construing ambiguities against the drafter. Explanation: when a will contains ambiguous language, courts apply rules of construction to determine the testator's intent. Answer D is correct because courts often resolve ambiguities against the drafter of the will, particularly if the will was prepared by an attorney or third party. Answer cypres applies to charitable trusts, not wills. Answer B. Dependent relative revocation applies to mistakenly revoked wills. Answer C. Rule of perpetuities prevents indefinite property control but does not resolve ambiguities. Thus the correct answer is D. Courts interpret unclear language against the drafter. Question 12. During an emergency response where multiple areas are impacted by sudden incapacity, a family must determine the validity of a durable power of attorney (POA). Under what condition would a durable POA remain valid after the principal becomes incapacitated? A. If it explicitly states that it remains effective despite incapacity. B. If it was executed within 1 year prior to incapacity. C. If it was signed by the principal in the presence of all beneficiaries. D. If the principal is declared incapacitated within 30 days of execution. Answer A. If it explicitly states that it remains effective despite incapacity. Explanation: the durable power of attorney (DPOA) remains valid even after the principal's incapacity if it explicitly states that intent in its language. Answer is correct because durability must be expressly stated in the POA. Answer B is incorrect because there is no time limit on validity. Answer C is incorrect because execution does not require beneficiaries to be present. Answer D is incorrect because incapacity timing does not affect validity. Thus is the correct answer. Question 13. In an environment where different components must interact for effective asset distribution, a trustee is tasked with managing a discretionary trust. Which of the following best describes the trustee's duty in making distributions? A. The trustee must follow strict guidelines set by state law rather than the trust document. B. The trustee has discretion over distributions but must act in good faith and consider the beneficiary's needs. C. The trustee must obtain unanimous consent from all beneficiaries before making distributions. D. The trustee cannot make any distributions unless specifically instructed by court. Answer B. The trustee has discretion over distributions but must act in good faith and consider the beneficiary's needs. Explanation: discretionary trust gives the trustee flexibility in making distributions. However, the trustee must act in good faith and in the best interest of the beneficiaries. Answer B is correct because trustees must exercise discretion reasonably and consider the trust's purpose. Answer is incorrect because state law does not override the trust's terms unless the trust is silent. Answer C is incorrect because trustees do not need beneficiary consent. Answer D is incorrect because court approval is not required unless specified. Thus, B is the correct answer. Question 14. When improving a process that shows unexpected results in estate tax calculations, a tax advisor reviews a decedent's final estate valuation. What is the primary reason an estate may elect the alternate valuation date for federal estate tax purposes? A. To reduce estate tax liability by using asset values 6 months after the decedent's death. B. To adjust for inflation and ensure fair market valuation. C. To provide beneficiaries with the highest possible step-up in basis. D. To account for any charitable deductions applied retroactively. Answer A. To reduce estate tax liability by using asset values 6 months after the decedent's death. Explanation: the alternate valuation date Act under ERSSS allows estates to value assets 6 months after death if doing so reduces estate tax liability. Answer is correct because Act is used primarily to lower estate taxes. Answer B is incorrect because Act does not adjust for inflation. Answer C is incorrect because app is not designed to maximize the step up in basis. Answer D is incorrect because charitable deductions do not affect app. Thus is the correct answer. Question 15. While updating traditional approaches where interconnections between probate and non-probate assets must be clarified, which of the following assets typically bypass probate? A. Assets distributed through a will's residuary clause. B. Jointly owned property with rights of survivorship. C. Solely owned real estate with no beneficiary designation. D. Tangible personal property without payable on death. POD designation. Answer B. Jointly owned property with rights of survivorship. Explanation. Jointly owned property with rights of survivorship automatically transfers to the surviving owner, bypassing probate. Answer B is correct because joint ownership with survivorship ensures automatic transfer. Answer O is incorrect because a will's residuary clause does not prevent probate. Answer C is incorrect because solely owned property must go through probate. Answer D is incorrect because tangible personal property without POD must be probated. Thus, B is the correct answer. Question 16. During a seamless transition where continuity must be maintained in business succession planning, what estate planning tool is most commonly used to ensure a smooth transfer of business interests? A. Irrevocable life insurance trust, ILET. B. Buy-sell agreement. C. Testamentary trust. D. Payable on death, POD account. Answer B. Buy-sell agreement. Explanation. A buy-sell agreement ensures business continuity by prearranging the transfer of ownership when an owner dies or exits. Answer B is correct because it provides a legally binding succession plan. Answer is incorrect because an ILET manages insurance proceeds, not business interests. Answer C is incorrect because a testamentary trust takes effect at death but does not ensure business continuity. Answer D is incorrect because a POD account does not transfer business interests. Thus, B is the correct answer. Question 17. When developing a solution that must address opposing needs in an estate plan, a financial advisor recommends a qualified terminable interest property (QTIP) trust. What is the primary benefit of a UAPA trust in estate planning? A. It allows the grantor to bypass estate taxes entirely for all beneficiaries. B. It provides income to a surviving spouse while preserving principal for remainder beneficiaries. C. It distributes assets equally to all heirs without restrictions. D. It eliminates the need for probate, regardless of the asset types included. Answer B. It provides income to a surviving spouse while preserving principal for remainder beneficiaries. Explanation. A UAPA trust is designed to provide income to a surviving spouse while ensuring that the remaining assets go to specific beneficiaries upon their death. Answer B is correct because QTIP trusts allow control over how assets are distributed after the surviving spouse's passing. Answer is incorrect because estate taxes may still apply to the final distribution. Answer C is incorrect because QTIP trusts do not mandate equal distribution. Answer D is incorrect because probate may still be required for other estate assets. Thus, B is the correct answer. Question 18. While analyzing the root causes of sequential problems in business succession, an entrepreneur is concerned about potential liquidity issues upon their death. Which estate planning tool is most effective in addressing this concern? A. A revocable living trust. B. A buy-sell agreement funded by life insurance. C. A pour-over will. D. A self-cancelling installment note, SIN. Answer B. A buy-sell agreement funded by life insurance. Explanation. Liquidity issues arise when heirs lack the cash to cover estate taxes or buy out a deceased owner's business interest. Answer B is correct because buy-sell agreement funded by life insurance ensures liquidity for business continuation. Answer is incorrect because revocable trust helps with probate but does not provide liquidity. Answer C is incorrect because pour-over will transfers assets into trust but does not create liquidity. Answer D is incorrect because an SIN is used for installment sales, not liquidity planning. Thus, B is the correct answer. Question 19. In a high-stakes environment where multiple challenges arise in trust administration, a trustee is concerned about a beneficiary's reckless spending. What is the best type of trust to restrict access to assets while still providing financial support? A. Special needs trust. B. Spendthrift trust. C. Simple trust. D. Charitable remainder trust. Answer B. A spendthrift trust. Explanation. A spendthrift trust limits a beneficiary's ability to waste assets or lose them to creditors. Answer B is correct because the trustee controls distributions and prevents reckless spending. Answer is incorrect because special needs trust is designed for disabled beneficiaries. Answer C is incorrect because simple trusts require income distributions but do not protect against poor spending habits. Answer D is incorrect because RTS for charitable giving, not asset protection. Thus, B is the correct answer. Question 20. During a major transformation where existing methods for gifting assets are being reevaluated, what is the primary advantage of using a grantor retained annuity trust (GRAT)? A. It allows the grantor to transfer assets with reduced gift tax liability. B. It ensures that all trust assets are included in the grantor's taxable estate. C. It provides immediate access to trust assets for all beneficiaries. D. It eliminates estate taxes entirely on transferred assets. Answer A. It allows the grantor to transfer assets with reduced gift tax liability. Explanation. A GRAT allows a grantor to transfer appreciation of assets to heirs while minimizing gift tax exposure. Answer is correct because GRATs allow tax-efficient wealth transfer. Answer B is incorrect because only the retained annuity portion remains in the grantor's estate. Answer C is incorrect because beneficiaries must wait until the GRAT term ends. Answer D is incorrect because estate taxes may still apply depending on timing. Thus is the correct answer. Question 21. In a situation where resource allocation becomes a concern in an estate, which of the following assets is most likely to be subject to forced heirship laws? A. Life insurance proceeds payable to a named beneficiary. B. Assets held in a revocable trust. C. A family-owned business in a civil law jurisdiction. D. Real estate owned jointly with rights of survivorship. Answer C. A family-owned business in a civil law jurisdiction. Explanation. Forced heirship laws, common in civil law countries, require certain heirs to receive a fixed share of the estate. Answer C is correct because business assets may be subject to forced heirship rules in certain jurisdictions. Answer is incorrect because life insurance passes outside of the estate. Answer B is incorrect because revocable trusts avoid forced heirship in many cases. Answer D is incorrect because joint tenancy ensures automatic transfer outside of the estate. Thus, C is the correct answer. Question 22. When implementing backup procedures across various financial institutions, what estate planning tool ensures continuity of management in case of incapacity? A. A living will. B. A testamentary trust. C. A durable power of attorney. D. A holographic will. Answer C. A durable power of attorney. Explanation. A durable power of attorney (DPOA) allows a designated person to manage finances if the principal becomes incapacitated. Answer C is correct because it ensures someone can act on the principal's behalf. Answer is incorrect because living will covers medical decisions, not finances. Answer B is incorrect because testamentary trust only takes effect after death. Answer D is incorrect because holographic will does not address incapacity. Thus, C is the correct answer. Question 23. While examining inconsistencies across various units in an estate plan, which factor primarily determines whether an asset is included in a taxable estate? A. The fair market value at the time of acquisition. B. The asset's location and governing jurisdiction. C. Whether the decedent retained control over the asset. D. The manner in which beneficiaries are designated. Answer C. Whether the decedent retained control over the asset. Explanation. For estate tax purposes, assets controlled by the decedent at death are included in the taxable estate. Answer C is correct because retention of control triggers estate inclusion. Answer is incorrect because estate taxes are based on value at death, not acquisition. Answer B is incorrect because jurisdiction matters, but control is the key factor. Answer D is incorrect because beneficiary designations affect probate, not necessarily estate tax inclusion. Thus, C is the correct answer. Question 24. In a large organization where multiple departments need to coordinate their estate planning strategies, what is the primary advantage of using an irrevocable life insurance trust? A. It allows the policyholder to borrow against the insurance proceeds. B. It removes the life insurance proceeds from the taxable estate. C. It guarantees equal distribution of assets among beneficiaries. D. It automatically converts to a revocable trust after the grantor's death. Answer B. It removes the life insurance proceeds from the taxable estate. Explanation. An ILED is used to keep life insurance proceeds out of the estate, reducing estate taxes. Answer B is correct because ILEDs ensure the insurance payout is not included in the taxable estate. Answer A is incorrect because once an ILED is set up, the policyholder loses direct access to the funds. Answer C is incorrect because the trustee determines distributions based on the trust terms. Answer D is incorrect because ILEDs remain irrevocable. Thus, B is the correct answer. Question 25. During a critical transition period where existing processes for asset distribution are being reassessed, what is a major advantage of a pour-over will? A. It ensures that all assets avoid probate. B. It automatically transfers unallocated assets into a trust upon death. C. It allows the executor to override trust terms if necessary. D. It eliminates the need for a trustee. Answer B. It automatically transfers unallocated assets into a trust upon death. Explanation. A pour-over will direct any remaining assets into a trust after death. Answer B is correct because it ensures unallocated assets are transferred into a trust. Answer is incorrect because assets in a pour-over will may still go through probate. Answer C is incorrect because an executor cannot override trust terms. Answer D is incorrect because a trustee is still required to manage the trust. Thus, B is the correct answer. Question 26. When dealing with a complex system that shows occasional inconsistencies in estate tax calculations, which of the following transfers would likely be subject to the federal gift tax? A. A transfer of assets into a revocable living trust. B. A payment of tuition made directly to an educational institution. C. A gift of $100,000 in cash to an unrelated individual. D. A charitable donation to a qualified nonprofit organization. Answer C. A gift of $100,000 in cash to an unrelated individual. Explanation. The federal gift tax applies to gifts above the annual exclusion unless an exemption applies. Answer C is correct because a $100,000 cash gift exceeds the annual exclusion limit. Answer is incorrect because transfers to revocable trusts are not considered completed gifts. Answer B is incorrect because direct tuition payments are exempt from gift tax. Answer D is incorrect because charitable gifts to qualified organizations are exempt. Thus, C is the correct answer. Question 27. In a high-stakes environment where multiple challenges impact the succession of a family business, which estate planning tool is best suited to ensure a smooth transfer of ownership? A. A revocable living trust. B. A family limited partnership FLP. C. A generation skipping trust. D. A pay on death pod account. Answer B. A family limited partnership FLP. Explanation. A family limited partnership FLP allows for structured business succession while minimizing tax liability. Answer B is correct. KFPS provide control business transfers while reducing estate taxes. Answer is incorrect because a revocable trust does not offer the same tax benefits or structured control. Answer C is incorrect because a generation skipping trust is for wealth transfer, not active business succession. Answer D is incorrect because a pod account is used for simple bank account transfers. Thus, B is the correct answer. Question 20. While investigating a complicated issue between different heirs regarding the division of real estate, which legal mechanism ensures that one heir can buy out the others? A. A tenancy in common agreement. B. A right of first refusal clause. C. A revocable living trust. D. A joint tenancy with a right of survivorship. Answer B. A right of first refusal clause. Explanation. A right of first refusal clause gives one heir the option to purchase property before it is sold to outsiders. Answer B is correct because it prevents forced liquidation and allows an heir to retain ownership. Answer is incorrect because tenancy in common allows partition but does not ensure a buyout. Answer C is incorrect because revocable trusts help with probate avoidance, not ownership disputes. Answer D is incorrect because joint tenancy automatically transfers ownership to the surviving co-owner. Thus, B is the correct answer. Question 29. When implementing new protocols in a shared environment that includes charitable donations, what is the primary benefit of a charitable remainder trust CRT? A. It allows the donor to retain an income stream while benefiting a charity. B. It guarantees a fixed percentage distribution to beneficiaries. C. It eliminates capital gains tax on all assets within the trust. D. It requires an equal split of assets between multiple charities. Answer A. It allows the donor to retain an income stream while benefiting a charity. Explanation. A charitable remainder, thus CRT, provides an income stream to the donor while ultimately benefiting a charity. Answer is correct because RTS allow donors to receive income before the remainder goes to charity. Answer B is incorrect because distributions depend on the trust type, annuity or unit trust. Answer C is incorrect because RTS defer but do not necessarily eliminate capital gains taxes. Answer D is incorrect because the donor chooses the distribution terms. Thus is the correct answer. Question 30. In a scenario where efficiency decreases across multiple generations in wealth transfer, what is a primary advantage of using a dynasty trust? A. It allows assets to pass to multiple generations while minimizing estate taxes. B. It requires distributions to be made equally among all descendants. C. It expires after the second generation of beneficiaries. D. It guarantees that all assets remain within the immediate family. Answer A. It allows assets to pass to multiple generations while minimizing estate taxes. Explanation. A dynasty trust is designed to preserve wealth across multiple generations while avoiding estate taxes. Answer is correct because dynasty trusts prevent repeated estate taxation. Answer B is incorrect because distributions are based on trust terms, not automatic equality. Answer C is incorrect because a dynasty trust can last indefinitely in states that allow it. Answer D is incorrect because dynasty trusts can include provisions for future generations beyond the immediate family. Thus is the correct answer.